Okay, welcome back everyone to Grockit's OGTV. This is the GMAT edition, so if you were tuning in to the SAT, you missed it I think by about 12 hours. It will be on again in about 12 hours. Actually, I think it's more like 9 hours or 10 hours. But anyway, the schedule is posted on Grockit.com, and that's where you are on Grockit. My name is Jim Jacobson. I will be your instructor today for this GMAT reading comprehension. I was going to call it an extravaganza, but actually today is going to be a little bit shorter because of the effort to end at the end of a passage. And the next two passages are fairly long. Just to finish the bit of background, we are in the 12th edition to the official guide to the test. If this is your first time watching, we are on page 382 with a longer passage with a larger number of questions. And the next passage, which we aren't going to get to today, also is a longer, more involved passage with 6 questions. So we just decided to schedule it so that we would only do the one fairly tricky passage with 7 questions today. Anyway, like I was saying, Grockit.com, OGTV, going question by question, cover to cover, just not necessarily always at the same pace because we do try to end these at logical stopping points. So, since it's going to be a little bit shorter session, I can give that little bit of background again. What's going to happen is I will take some notes I will give you some time to read the passage, and I'm going to give you closer to 5 minutes on this one because it's actually a little bit trickier. It involves legal precedents and stuff like that, so it's a fairly tricky case. And when you're doing practice on your own, of course, when you do full-length practice tests, all of that is going to be timed. But when you're doing just kind of content practice, whether it's sentence correction or triangle questions or whatever, I really do advocate the use of untimed practice as well as timed practice, especially when it's trickier stuff. Because untimed, if you do hard stuff initially with a time limit, you will never necessarily get the sense of what it feels like to get those harder questions right. I mean, you may be able to get you have that flash of insight and you see the answer immediately and you get it done as quickly as you would an easier one. But especially with reading comprehension, with trickier questions where you really have to hunt for support for your answers, it's good to practice doing some with all the time in the world so that you can practice getting used to that feeling of finding the right answer, seeing how it's done, and getting faster at that skill so that when you do timed practice on a full-length test, for example, it feels more familiar. Also, it creates a different type of work for you to do when you set up your study schedule. So you can set up separate times for timed practice and untimed practice. They feel pretty different to me. And having more than one type of task can break up the monotony of studying for hours and hours. So anyway, what was the point of that? The point is that it's okay to allow ourselves a little bit of extra time on a relatively tough passage. And of course, if you're watching this on a recorded basis, you can pause to watch the you can pause to read while and then hit play again when you start up again. Sorry, I lost my train of thought. Anyway, so without let's get rid of that there. So I'll leave it there. No, I'm going to get rid of it. There we go. So we are on page 382, and we are on question number 57. So as before, I will give you some amount of time to read. I'll take notes, and my notes will definitely be more thorough on this one because with all the legal precedents and stuff like that, it could be hard to follow. You, of course, again, are not obligated to take notes, but I think it's a good habit to get into, even if they're just brief notes. So anyway, we'll go with almost 5 minutes from where we are now. And yeah, so get started. I'll take notes, and you should too. Okay, we'll stop there. And obviously I wrote a lot on this one. Again, this is much more, I don't know about much more. This is more in depth than the notes would be if I were taking it on my own. I would have abbreviated a lot of things, probably, just a lot of partial words and a lot more arrows like this to to do kind of shorthand. And but I wanted this to be legible to the rest of you to show what sorts of things I thought were important in the passage. One, of course, was mentioning the court cases, keeping the two separate. The other is that when they actually go to the trouble to list procedures or theories or elements of something, those are often very important. In this particular case, because they actually put the numbers in front of them in the passage, it was less important that that I list them in the notes because they're easy to find. They're easy to visually pick out of the passage. Most of the time when they list the elements, or in this case, I guess these are conditions under which the federal government has rights to reserve water. If these hadn't had the numbers, I think it would have been even more useful to have written them down because it can be challenging to pick that bit of text out. Anytime that you have to spend going back and reading something you didn't actually need to read to find the thing that you actually did need to read is time wasted on reading comprehension. And with a longer passage, I think a kind of a tougher passage, that's time that you could have back to get another critical reasoning question or another sentence correction question right. So anyway, let's do question number 57 and we'll see how the notes hold up. Again, it's not that important that the notes be awesome. It's not important. It's okay if they don't get used at all, but if they do get used, it makes our life that much easier. And again, the act of note-taking alone is helpful in straightening these things out in your head. Or at least it's helpful in straightening things out in my head, and since I'm the one who has to talk over the internet to however many people, I'm going to keep doing it. Anyway, question number 57. According to the passage, which of the following was true of the treaty establishing the Fort Belknap Indian Reservation? So we find out about the treaty establishing that reservation in the first paragraph, and it's really the first half of the first paragraph, but we'll have to see what the answer choices are really before. There's not one specific line. I mean, the treaty is mentioned in line 4 and 5. So it says, so in Winters v. United States in 1908, the Supreme Court held that the right to use waters flowing through or adjacent to the Fort Belknap Indian Reservation was reserved to American Indians by the treaty establishing the reservation. That's the first reference to the treaty. The second sentence is, although this treaty did not mention water rights, the court ruled that the federal government, when it created the reservation, intended to deal fairly with American Indians by reserving for them the waters without which their lands would have been useless. So, all we really find out about the original treaty is that it's the basis for Winters v. United States, and that it did not specifically mention water rights. So we would want to have something like that in our answer choices. A, it was challenged in the Supreme Court a number of times. If you skimmed the passage, this one might be tempting because, of course, it does... the rest of the passage is all about further complications and things like that. So if you didn't really read it and just were choosing things quickly, that one might end up looking interesting, but in no case is it challenged. It's precedent for a number of things, which is to say it is the basis for a number of other legal decisions, but it's not ever actually challenged, so it's not A. B, it was rescinded by the federal government, an action that gave rise to the Winters case. Rescinded means taken back. And it definitely wasn't rescinded because, again, it was the basis for other decisions that were made later. So that can't be it either. Vocabulary isn't a big part of the GMAT, but occasionally vocabulary words that are a little bit rarer will turn up in passing in both the passages and in the questions. C, it cited American Indians' traditional use of the land's resources. So Winters v. United States does cite that, as well as the decision basically to make the Rio Grande Pueblos to establish water rights for them. Those also cite American Indians' traditional use of the land's resources. The original treaty, however, is not said to have done that. It may well have. I haven't read the treaty, but the passage, this is a detailed passage, so according to the passage, it needs to be cited in the passage. So it doesn't say anything about their traditional land use in the treaty part of the passage. D, it failed to mention water rights to be enjoyed by the reservation's inhabitants. So that is something that we saw. It said the treaty did not mention water rights in lines 5 and 6. So that's almost certainly the right answer. Choice E, it was modified by the Supreme Court in Arizona v. California. And that's actually the reverse of what's true. In line 39, basically it said that it didn't actually have that much to do with Winters v. United States. This is line 36 actually. This pragmatic approach is buttressed by Arizona v. California in 1963, wherein the Supreme Court indicated that the manner in which any type of federal reservation is created does not affect the application to it of the Winters Doctrine. So even though the original Winters v. United States was about, well, the treaty didn't mention water rights, but there was a treaty, and the treaty intended to give them the use of their land, Arizona v. California says, well, there doesn't even have to have been a treaty. They still get to use the land and the water, more relevant to the passage. So while it doesn't, it's actually Winters v. United States that was, well, it's not really modified, but strengthened by Arizona v. California, not the original treaty establishing the reservation. So we basically have three different legal contracts or legal things here. We have the actual treaty in order. 2, we have Winters v. the United States. And 3, we have Arizona v. California. And we need to keep those 3 straight in order to get the questions right. Anyway, so it is in fact D, the treaty failed to mention water rights to be enjoyed by the reservation's inhabitants. All right, number 58. The passage suggests that if the criteria discussed in lines 10 to 20 were the only criteria for establishing a reservation's water rights, which of the following would be true? So, this is where it starts to get a little trickier. The passage suggests means, of course, it's an inference question. We have to infer something that's not in the passage based on what is in the passage. And the criteria discussed in lines 10 to 20 are these guys, right here. That's lines 10 to 20. And it looks like this gets referred to in another question, so I'll just leave that label there. If those were the only criteria for establishing water rights, which of the following would be true? And so any of these things that appear in the answer choices are not in the passage. They just need to be true based on the criteria established. So there's nothing else that we can really look for in advance in the passage. So A, would it be true that the water rights of the inhabitants of the Fort Belknap Indian Reservation would not take precedence over those of other citizens? So there's nothing in these criteria about water rights taking precedence over those of other citizens. Because basically these just establish that the federal government can set aside water rights for more or less its own uses of any kind. So if anything, when the federal government reserves water rights for its own uses, it takes them away from the public. That's actually what it says here in number 2. And then if that other purpose of the federal government is to then give them to a particular group of people, then those people on the Fort Belknap Indian Reservation, their water rights would take precedence over those of other citizens, because if it's, federal land initially and it's reserved and withdrawn from the public, remember that's in criterion number 2, then the federal purpose would take precedence over the rights of other citizens. So, choice A is not correct, because it would give precedence to the inhabitants of the reservation. Maybe this is just amazingly, blindingly easy for you. I find these questions fairly involved in the reasoning. So, your mileage may vary. I guess you can just close the window if this is too easy for you and you'd rather wait for something that you find tricky. Anyway, statement or answer choice B. Reservations established before 1848 would be judged to have no water rights. There's no date range in the Winters v. United States criteria. And in fact, the third criterion in the list says that even if water rights weren't mentioned, if there was originally an intent to reserve the water because of the way that the agreement is worded, then then there would be water rights even if they weren't originally mentioned. So basically, criterion number 3 extends the water rights potentially backwards to any agreement for the entire history of the country. So it's not B. There are no date ranges. C, there would be no legal basis for the water rights of the Rio Grande Pueblos. So the Rio Grande Pueblos are in a different section of the passage. In them, we find out that, let's see, line 27. Although they at that time became part of the United States, this is in 1848, the Pueblo lands never formally constituted a part of federal public lands. In any event, no treaty, statute, or executive order has ever designated or withdrawn the Pueblos from public lands as American Indian reservations. So, the criteria mentioned in lines 10 to 20 say that the land has to be an exclusive enclave of federal jurisdiction. It needs to be withdrawn from the public. And so those two things never happened in the case of the Rio Grande Pueblos. And so if these criteria were the only things that were true, then C, that would be true. There would be no legal basis for the water rights of the Rio Grande Pueblos. So this sounds pretty good. And it's actually then this third legal decision, Arizona v. California, that establishes that that's okay. They still get it. Let's just look at the other answer choices, though, to again, to make ourselves as familiar as possible with how wrong answer choices are constructed. D, reservations other than American Indian reservations could not be created with reserved water rights. So the criteria do not specifically mention American Indian reservations only. These are true of any type of reserved land, federally reserved land for any purpose. So it's definitely not D. And then E, treaties establishing reservations would have to mention water rights explicitly in order to reserve water for a particular purpose. And that's again what number 3 on this list is doing. Number 3 says that even if you didn't originally mention water rights, you're still covered if it looked as if the intent was to let somebody use all aspects of the land. So E is definitely not it, and that leaves us with C. There would be no legal basis for the water rights of the Rio Grande Pueblos because they were never actually withdrawn from the public or done anything. Nothing was ever done to those lands. They were just made a part of the United States the same way that almost every other part of the United States is part of the United States. Nonetheless, they have water rights. Answer choice C. Oh, and we're on the next page. So 383, question number 59. Which of the following most accurately summarizes the relationship between Arizona v. California in lines 38 to 42 and the criteria citing the Winters Doctrine in lines 10 to 20? So remember the criteria, of course, we just talked about in depth with that question, the previous question. And Arizona v. California was this third in the series of legal decisions mentioned. And it basically said that the lack of treaty, the lack of a formal treaty doesn't necessarily matter in some cases. The manner in which any type of federal reservation is created does not affect the application to it of the Winters Doctrine. So if it's in any way regarded as a reservation, all of these things in Winters v. U.S. apply. So let's look for something like that. A, Arizona v. California abolishes these criteria and establishes a competing set of criteria for applying the Winters Doctrine. Again, line 37, it says this pragmatic approach is buttressed. Buttressed means, buttress is a architectural term for a type of support for keeping walls from falling down, really tall walls. So it means strengthened. So definitely Arizona v. California does not abolish the criteria of Winters v. U.S. It strengthens them. So we don't even really have to worry about what happens in the second and third lines of answer choice A, because the first line completely ruins the answer choice. Well, ruins in the sense of makes it impossible to be right. B, Arizona v. California establishes that the Winters Doctrine applies to a broader range of situations than those defined by these criteria. So that sounds a lot like what we were talking about and thinking would be the case, namely that Arizona v. California, it applied to those Rio Grande Pueblos, which weren't ever really withdrawn from the public, but they still get water rights. So that sounds good. C, Arizona v. California represents the sole example of an exception to the criteria as they were set forth in the Winters Doctrine. Since really all it does is say the Winters Doctrine applies in some other cases, it's not an exception. And it's certainly not a sole exception. We just get one example of it in the passage, but there's no mention of it being the only such thing. Not C. D, Arizona v. California does not refer to the Winters Doctrine to justify water rights, whereas these criteria do rely on the Winters Doctrine. Well, so yes, the criteria do rely on the Winters Doctrine. That part's true. Arizona v. California does not refer to the Winters Doctrine to justify water rights. Well, I mean, it specifically says, the Supreme Court indicated that the manner in which any type of federal reservation is created does not affect the application to it of the Winters Doctrine. So if that's not a citation of the Winters Doctrine, I'm not sure what is. So it's not D. And then E, Arizona v. California applies the criteria derived from the Winters Doctrine only to federal lands other than American Indian reservations. Well, I mean, I think the idea here is that the Rio Grande Pueblos are in some form an American Indian reservation, even though they're not one established by treaty or statute. So, and certainly were never excluded from public lands as reservations. Yet they are still considered reservations, and so, and that's what Arizona v. California was about. It was about these reservations that aren't reservations in the same way that the Belknap Indian Reservation is. So it's not true that Arizona v. California only applies to federal lands other than American Indian reservations. Is it? I guess there's no way that you can tell me whether this is making sense to you or not. Again, this is why I think this one is a relatively challenging passage. It's because the logic behind it, I mean, the words themselves, there aren't really too many tricky words in the passage, buttressed maybe, but the logic of what's going on and the application of legal status of a variety of things to me makes this one fairly challenging. I guess let's go with I personally would find this a challenging passage if I ran into it on the GMAT. You can write on the Facebook page whether you thought this was a challenging passage. And I'll check it when we're done. Question number 60. The pragmatic approach mentioned in lines 37 to 38 of the passage is best defined as one that. We need to go back and reread that sentence, 37 to 38. It says, this pragmatic approach is buttressed. Well, so this pragmatic approach clearly refers to something that was just mentioned, so we need to go back and read that, which is actually line 34. What constitutes an American Indian reservation is a question of practice, not of legal definition, and the Pueblos have always been treated as reservations by the United States. This pragmatic approach, namely treating things as reservations even when they aren't necessarily legally, is buttressed by Arizona v. California, blah, blah, blah. Okay. So, that pragmatic approach, treating things as reservations that weren't necessarily legally established as such. A, does that pragmatic approach grant recognition to reservations that were never formally established, but that have traditionally been treated as such? Well, that sounds exactly like that pragmatic approach, but let's look at the other answers. The pragmatic approach determines the water rights of all citizens in a particular region by examining the actual history of water usage in that region. There's nothing remotely like that in the passage. No, that's not actually true. The whole thing with the Rio Grande Pueblos is that they traditionally used water in a certain way, diverted it for their own use in the Pueblos, but the pragmatic approach doesn't determine the water rights of all citizens in a particular region by doing that. It just was an example used of the Pueblos. C, does the pragmatic approach gives federal courts the right to reserve water along with land, even when it is clear that the government originally intended to reserve only the land? Well, this isn't really true. The Winters Doctrine actually does the opposite of this. It says that even when they only reserved the land, if the intent was to reserve the water, then that gives them the right to reserve the water as well. There's nothing actually in the passage that says, even if they explicitly said, you get the land but not the water, there's no pragmatic approach. There's nothing in the passage that reverses that ability if water is specifically excluded from an agreement. So this is kind of extreme. It uses the same kind of language as criterion number 3, which is before the part on the pragmatic approach in lines 37 and 38 anyway. So C is just using some familiar sounding language in kind of a reverse way from the wrong section of the passage. It's meant to attract people who are skimming. D, does that pragmatic approach base the decision to recognize the legal rights of a group on the practical effect such a recognition is likely to have on other citizens? For better or for worse, the passage never addresses the effect of reserving water on other citizens. So that's just outside the scope of the passage. I'm sure there are whole books written on the subject, but this passage is not that sort of thing. The pragmatic approach dictates that courts ignore precedents set by such cases as Winters v. United States in deciding what water rights belong to reserved land. No, the pragmatic approach is basically saying totally look at Winters v. United States in cases more than just what it originally applied to. So choice E is in fact the direct opposite of what the pragmatic approach actually is. So it's not that. So that leaves us with answer choice A, that it says granting recognition to reservations that were never formally established but have been traditionally treated as such, like the Rio Grande Pueblos. Maybe it's just my long-winded explanations of these things, but I don't think this session is going to be as short as I feared. We still have 3 more questions. 61. The author cites the fact that the Rio Grande Pueblos were never formally withdrawn from public lands primarily in order to do which of the following? Well, it is somewhat in opposition to what the criteria are for Winters v. U.S. Number 2 in our list of criteria, this important one here, it seems like there's some kind of opposition going on. So, choice A. Does the author cite the Rio Grande Pueblos in order to suggest why it might have been argued that the Winters Doctrine ought not apply to Pueblo lands? Well, yeah, that sounds likely. And of course, then the passage goes on to uh, show the legal stuff, like Arizona v. California, that then brings Pueblo lands under the Winters Doctrine. So the Rio Grande Pueblos sound like they ought to be an exception based on the criteria we had just heard about, but then they turn out not to be. So that sounds pretty good. B, is it to imply that the United States never really acquired sovereignty over Pueblo lands? No, I mean, it's mentioned in 2 sentences in a row. For example, the Rio Grande Pueblos already existed when the United States acquired sovereignty over New Mexico in 1848. That's lines 24 through 27. And then the very next sentence, although they at that time became part of the United States, the Pueblo lands never formally constituted a part of federal public lands, blah, blah, blah. So sovereignty is mentioned without any kind of equivocation or undermining. So no, I don't think the author is implying that they don't really have that the U.S. doesn't have sovereignty. Sovereignty is like rulership, not more than an ownership. It's kind of like jurisdiction, but for countries. Anyway, saying that is their land. C, was it to argue that the Pueblo lands ought still to be considered part of federal public lands? Again, that whole section says that it's just never been that way, and so the author isn't really arguing for a change of anything. So this is one of those, when you read passages, try to decide whether the author is trying to advocate a course of action or argue that something should be a certain way that it is not currently. The author isn't arguing for any sort of change. The author is explaining a situation. So the author is not trying to argue anything. It's not C. D, is it to support the argument that the water rights of citizens other than American Indians are limited by the Winters Doctrine? Well, that's... Actually, we never really hear about other citizens anywhere in the passage, so, we can get rid of that. And is the author trying to suggest that federal courts cannot claim jurisdiction over cases disputing the traditional diversion and use of water by Pueblo Indians? Wow. Federal courts cannot claim... aside from the... and so, trying to guess the author's intent is something that's not in the passage. You're looking at you're looking at the argument structure. There's nothing in the passage that talks about directly about claiming the federal courts claiming jurisdiction anywhere. So on that basis alone, we could pretty safely eliminate E. When you think about it, one step further, though, it's even more clearly not E, because we did already establish that in eliminating answer choice B, that the federal government has established sovereignty over the Rio Grande Pueblo lands, even though they're treated as a reservation. And so that technically, because they are still part of the sovereign state of the United States, the federal courts would have jurisdiction over it. So we can infer doubly that answer choice E is not it. Which brings us back to A. The Rio Grande Pueblos are something of an exception, at least until Arizona v. California comes along. 2 more. Oh, crap. Oh, no. I just deleted them. Well, we'll get by without them. So, page... Whoops. 383. The buttons for changing the pen to white for me to quote-unquote erase things, and the button to clear the screen of all the writing I've done entirely are right next to each other. And maybe I should do something about that for future broadcasts. Okay. Question 62. The primary purpose of the passage. Oh, so we do get one on the primary purpose. All right, so which of these sounds like what the author was trying to do? Again, we established that the author is explaining rather than advocating or persuading. Is the purpose to trace the development of laws establishing American Indian reservations? No, it's actually sounded pretty good until we got to American Indian reservations in this answer choice. Had it said to trace the development of laws establishing water rights on American Indian reservations, that would have sounded pretty good. It doesn't, though, without the water rights thing. B, explain the legal basis for the water rights of American Indian tribes. Well, that sounds a lot more like it. C, question the legal criteria often used to determine the water rights of American Indian tribes. There's not really questioning. It's really just explaining, so it's not that. D, discuss evidence establishing the earliest date at which the federal government recognized the water rights of American Indians. Well, that does happen in the beginning of paragraph 1. So this Winters v. United States is the first kind of legal exploration establishing water rights even when those water rights were not specifically granted by treaty. But it doesn't actually say whether there were some other treaties that established reservations that explicitly mentioned water rights before Winters v. United States. So we're not even sure that that's the earliest establishment of water rights, that we can't be sure that Winters v. United States is the earliest date at which the government recognized the water rights of American Indians. There could be a flat-out reservation treaty that includes water rights in the treaty. So it's not D. It's just not in the passage. And E, and it's also, even if that were in the beginning of paragraph 1, something that said, the first treaty establishing water rights was in 1802 or something like that. That's not what the whole passage is about. The passage as a whole is about water rights, so choice D would still be just a detail from the passage, if it were there, which it isn't. E, point out a legal distinction between different types of American Indian reservations. So the passage does imply that there are different types established in different ways, but there's certainly no legal distinctions between them made. So that brings us back to B. The purpose of the passage was basically about water rights. So what's that one? All right. I guess there's no point in not erasing the whole thing now. Page 383. Question number 63. Finally, the passage suggests that the legal rights of citizens other than American Indians to the use of water flowing into the Rio Grande Pueblos are. So, this one is definitely an inference because we don't, other citizens are not mentioned anywhere in the passage, except by implication where we find out that because of treaties with reservations, the inhabitants of those reservations have claim on the water through those through their lands, and so really, I guess that's all we know about the legal rights of citizens other than American Indians to use the water flowing into the Rio Grande Pueblos. Let's see what we get in the answer choices. A, are the legal rights of citizens other than American Indians guaranteed by the precedent set in Arizona v. California? No, Arizona v. California basically gives rights to the people on the reservation, even though it's not really a reservation. So if anything, it does not guarantee the legal rights of non-Native American citizens. So it's not A. I'm going to cough. Excuse me. Not A. B, are their rights abolished by the Winters Doctrine? Well, the Winters Doctrine doesn't abolish anyone's rights at all. Well, no, that's not true. The Winters Doctrine says that the federal government can do whatever it wants to with waters in lands that have the three things in lines 10 to 20 done to them, which basically withdraws the use of those things from the public. However, the Rio Grande Pueblos waters were never actually withdrawn from public use legally. So the legal rights of citizens other than American Indians were not abolished by the Winters Doctrine because that land was never formally taken away. Actually, it doesn't really abolish anyone's rights anyway. So anyway, C. Are they deferred to the Pueblo Indians whenever treaties explicitly require this? So their rights are deferred to the Pueblo Indians because of this whole treating reservations as reservations even when they weren't formally established as a reservation. However, the second half of answer choice C is what makes it wrong. Whenever treaties explicitly require this doesn't make sense because, again, we learned that the Rio Grande Pueblos were not established by treaty. They were just kind of accepted as reservations even though that was never formally done. The thing about Pueblos, go read up on them on Wikipedia or something if you want, is that they are, basically little towns that existed before U.S. sovereignty of the area. So anyway, they definitely are not established by treaty, so it can't be C. Are the rights of legal rights of citizens other than American Indians guaranteed by federal land use laws? So federal land use laws do actually come up in the passage. It's in criterion number 2 of the Winters Doctrine. It says in order for the federal government can reserve water for particular purposes if 2, the land has been formally withdrawn from federal public lands, i.e. withdrawn from the stock of federal lands available for private use under federal land use laws and set aside or reserved. So this one's kind of tricky because, of course, the land has not been, the Rio Grande Pueblo land has not been withdrawn by the federal government as a reservation type area. Of any type. It hasn't been it hasn't been set aside as federal land, period. There is federal land, like national parks and stuff like that, where you can just go and, according to the land use guidelines of the law, you can do certain things, on that land. When it's regular federal land, the federal government can, however, reserve some of that federal land and do something else with it and make it something else. The Pueblo Indians in the Rio Grande Pueblos, their land is not set aside as federal land in any meaningful way at all, though. So the legal rights of citizens other than American Indians are not guaranteed by federal land use laws because their land is not federal land in that way. Whew. Yeah. I wish I could tell whether I wish I could see your faces sometimes so I could know whether that explanation just made sense to you. Anyway, we'll finish this question. Answer choice E. Are the legal rights of citizens other than American Indians limited by the prior claims of the Pueblo Indians? So really, this is the only fair choice. Because the Rio Grande Pueblos are treated as reservations, even though they aren't reservations, the people on the reservation have kind of the rights to that water. And whatever those rights consist of, then the things outside those rights are what citizens other than American Indians have. So the Pueblo Indians have certain rights to the water, and whatever is beyond those rights are what people who are not Pueblo Indians have. So the legal rights of citizens other than American Indians are limited by the prior claims of the Pueblo Indians. Yes, so it is answer choice E. Okay, I'm going to check the Facebook comments on the video page just to make sure nobody has written, "Oh my gosh, that doesn't make sense," or something like that, because I find this passage pretty tricky. It's going to take me a moment to navigate to that page. I'm doing it on a different computer, that's why you can't see me doing it on this screen. Yep, there's my screen. Nope, same comments as from before the holidays, or before Christmas. Anyway, okay. Well, thanks for joining me. I never thought I would spend almost an hour on 7 questions, but these I think were pretty tricky. Next time we will actually get through 2 passages, so we'll go a little bit faster, even though the passages are still fairly long. So, come back tomorrow, we'll get more done. Anyway, thanks for tuning in. My name's Jim Jacobson. I've been helping you through a tricky legal water rights passage. You've been watching Grockit's OGTV, the GMAT edition, Grockit GMAT, and we're going through the 12th edition of the guide, which I really can't imagine someone watching this broadcast without the book in front of them, but I guess it's possible. If I don't get, money for every time I suggest that someone go out and buy the official guide, but you'll get a whole lot more out of this broadcast if you have the official guide in front of you. So anyway, thanks for joining me, and I'll see you next time.